Okay, in this video I want to cover two very, very common mistakes that employees make. I'm going to do that right after this break. Okay, the first one is this. Recently, in May of 2017, the Supreme Court dealt with an employment-related claim, a bullying claim. The case is involving a special needs assistant who worked in a primary school in County Kildare, Una Ruffley, versus the Board of Management of St Anne's School. The case went to firstly the High Court, then the Court of Appeal, then the Supreme Court. But one thing jumped out at me from the judgments of the various judges, in particular Justice Peter Charlton. He said that not every wrong, even one which results from unfair or unfortunate circumstances, gives rise to a cause of action. That means that essentially shit happens. And sometimes stuff happens that you cannot bring a claim about, or you do not, or does not give rise to a cause of action, to a legal claim. In other words, there may be an infirmity or imperfection in, for example, the way that you are treated or an employee may be treated at work. There may be an imperfection or infirmity in, for example, the way a disciplinary procedure has been conducted in the workplace. You may not like, or the employee may not like, the way you've been spoken to by a line manager or an employer. But the bottom line is this. There's no guarantee of perfection. There's no guarantee of complete avoidance of dissatisfaction. The workplace does require a certain amount of robustness from employees, and this has been recognised in the Ruffley versus Board of Management of St Anne's school case in the Supreme Court. But the bottom line is, not every wrong, no matter how unfortunate, gives rise to a legal claim or a cause of action. That's the first thing. The second thing that I have discovered seen lately quite a lot is this. I have people coming to me with queries and issues, and they may bring in a file like this. And the file could be 6 inches or 9 inches or 12 inches deep. And it will contain emails and letters and notes and diary entries of every single event that has caused them dissatisfaction or unhappiness in the workplace. And the point that I want to make to you is this. No matter how thick the file, it cannot get over the very simple fact that you either have a claim, a legal cause of action, or you don't. So, boy gets girl, boy loses girl, boy gets girl again. That's a very, very short story, but within that short story is contained quite a lot of action, and it could be filled out or expanded upon. But essentially, if you come to me, or if you come to any solicitor, and you can tell me in a paragraph or two what has occurred in the workplace, and whether you have a claim, whether you have a cause of action or not, there's a good chance that even though I might need more information, there's a very good chance that I'll have a fair idea of whether you have a justiciable claim, a legal cause of action or not. But nothing can change the facts of the story, nothing can change the facts of the situation. And building up a file of 9 inches or 12 inches with grievances, with emails, with letters, with correspondence, etc., etc., is not going to increase or strengthen your case. Sorry about that intrusion. So there you go. In conclusion, two things. One, not every difficulty, not every slight, not every wrong, no matter how unfortunate in the workplace, gives rise to a cause of action. It may or it may not, but there's no perfection and shit happens. Number two, the strength or weakness of your case is essentially going to turn on the actual facts. And you cannot build a case by getting more paper or making more records, because the essential bones, the essential building blocks of your claim will be quite evident to a solicitor who has a good understanding of the law. I hope you find this useful. If you do, you might share with a friend, or sign up to or subscribe to my YouTube channel, or comment below, or give it a like, give it a thumbs up. Thank you for watching.